All right, good morning, everybody. It is time for the Thursday legal update. I'm Mitch Beinhacker. I'm a business attorney. I have a private practice in Clark, New Jersey, and I do business transactions and documents for business owners, executives, and professionals. I also do a lot of estate planning for those businesses as well as family-owned businesses. I am also the host of a podcast called The Accidental Entrepreneur, which you can find on iTunes and Google, Spotify, Stitcher, iHeartRadio, and TuneIn, which is Alexa. So I hope you'll listen, subscribe, where we interview guests and talk about ways that business owners can get a hold of what they're trying to do from a business standpoint. So today's update. On Tuesday, I covered the notarization of documents in New Jersey, specifically wills, living wills, powers of attorney. I got a question from somebody about witnessing. Can a spouse witness a document? So I mentioned before that with a will, at least, since you can't do online notarization yet in New Jersey, you can leave off the notary section and just sign it with two witnesses. That will make it, it'll be acceptable to court. It's not self-proving, so that you have to go through a couple of steps, but it doesn't make it invalid. So the question came to me, can a spouse be a witness? Or can a child, a young adult, 18 or older, be a witness? And the answer is yes. I would prefer that the spouse is not a witness on a document like the living will or the power of attorney, where they're being appointed as the power holder or as the healthcare representative. But for the will's purposes, okay for the spouse and okay for a child, 18 or older, to be a witness. Would it be better to have other people's witnesses? Sure, but under the circumstances, you got to do what you can do. So the other things we're going to talk about today are business planning. So it's a good time, given everything that's going on, for you as a business owner to pull out the documents that run your business and to kind of take a look at things. I find that when business owners are operating and they've been doing things for a long time, they kind of lose track of what their documents say, their operating agreement. I would review the powers that each member has, the managing member, what he or she can do on behalf of the company. Are you still kind of following those rules? Have things evolved where maybe it needs to be updated and changed? Because the last thing you want to do is you get into a disagreement with your partner, whether it's your family member or a non-family member, and you pull out your agreement, and then everybody goes back to the agreements and say, well, you're not doing this and you're not allowed to do that. And it gets to be a little crazy. I've had situations with business owners and family-owned businesses where over the years, the two siblings were 50-50 in running the business, and then one of them kind of doesn't really do much anymore. It's still 50-50, and they're still splitting profits, and it's creating animosity. And unraveling those situations and correcting those situations can be very difficult and very sticky and lead to a lot of problems that are costly from a litigation standpoint, legal standpoint, and so forth. So good time to do that. Also, I would pull out maybe buy-sell agreements if you have one, or if not, you probably have a section of your operating agreement. But buy-sell agreements would deal with the valuation of your business. If somebody were to die, become disabled, wants to walk away from the business, has a creditor issue, you should be updating valuation formulas. Some of the agreements, a lot of the agreements I do, I use what's called a certificate of agreed value. So on the back side of the agreement, there would be a schedule that lists the value of the company for whatever purposes and says how you came to it, and then it would be initialed and signed by each of the members. So you could update that, initial it, and maybe it's gone up, maybe it's gone down. Also, good time to contact your insurance advisor and make sure that your insurance is in place and the beneficiaries are correct. Sometimes I've seen situations where people buy insurance and they set up the insurance to be payable to the wrong people, and then they put an agreement in place later and they never update that kind of stuff. So a good time to take a look at that. Another issue came up the other day. Good time to look at trademarks and copyrights of materials that you have put together or ideas that you have trademarked. Typically, if you produce some materials, right now we do a lot of content marketing because we're all online. So if you produce something, you can write down you have a copyright, or you can put a TM next to something that you're trademarking. That's a common law trademark. And by the way, I preface my remarks by saying I'm not an intellectual properties attorney. So I know this peripherally. I do some of it for clients. I certainly don't do any patent work. And if you need trademarks, you need copyrights, I have some very good colleagues who can handle that for you. Back to what I was saying. So next to something you're trying to trademark, you can put a TM, little TM that's, superscript, and that gives you certain common law protections. It doesn't mean you're federally registered in the U.S. Patent and Trademark Office. If you see a trademark with a mark next to it that's an R with a circle around it, that's a registered mark. So a lot of people have TMs by their trademark, smaller business owners. They may have registered and they never changed the TM. So I was in discussions with someone the other day and I asked them, is this a registered mark? Oh, yeah, we registered the mark. So, well, how come you're not using an R with a circle around it? You don't have to, but you should. You'd want to, and gives you statutory protection. Well, the answer was, I know we filed something, but I don't know what we're doing. So it's a good time to take a look at that stuff. There are filing deadlines. There are you have to file that you're using the trademark, just because you can't just trademark something and then hold on for the rest of your life. I believe every 5 years you got to re-up your trademark and you got to show that it's being used. Trademarks become stronger and more protective as they're used more in commerce and so forth. So you have to show that you're still using it. And there's ways to resurrect a trademark, but a lot of times you do a search, you find a trademark in the USPTO. By the way, uspto.org, I believe, is you can go and do your own search for trademarks. It's an open database. And there may be marks there, but it might say dead or abandoned. And those marks have not been followed up on people. So you don't want to let those things lapse because they become problematic later on. It also may be a good time for you to take a look at your corporate structure. If you're an LLC, you're really subject to your operating agreement. If you don't have one, you may need one. You may need to put one in place because an operating agreement creates the rules of your LLC. Corporations, small business owners usually make an S election and are S corps, but some of them are still C corps, regular corporations, are subject to the rules of the state in which they're operating and have certain legal and statutory requirements. So one of the advantages of an LLC is that you kind of set the rules. With a corporation, you get certain protection, and if there's more people involved, you're looking to go public, raise money. Very often you're using a corporation, so you dole out shares, but there are certain statutory requirements you have to follow in order to maintain the corporate status. Generally, you have a corporation as a small business owner or an LLC for creditor protection. So if you get into trouble, somebody sues the business, there's some sort of another dispute, you're limited to your investment in the business, short of fraud or committing anything like that. You can't do that. So with a corporation, you have to have annual shareholder meetings and you have to keep corporate records and books. So if a lawsuit erupts between somebody you hurt or got hurt at work or an employee or whatever, the first thing a good attorney is going to do is request your corporate records and see if you've been following those rules. So you have less of those issues with an LLC than you do with an S corp from a legal standpoint. Now, there are all kinds of tax reasons to do an S corp over an LLC or vice versa. That's more up to your CPA. You should discuss it with him or her. But sometimes you got to weigh one against the other. As a lawyer, I'm much more preferable to LLCs these days than S corps, and I limit that to New Jersey. I'm a New Jersey attorney. I make my comments relative to New Jersey. Every state's a little bit different. New York, for example, has a publication requirement that can be anywhere from $1,200 to $1,500 in cost, an additional cost to publish the name of your LLC in certain publications. I have no idea why the history of that came about. You don't have to do that for corporations or partnerships or any other entity or DBAs, only for LLCs. And that may be true in other states. So you'd want to check it out. With S corps, in New Jersey, you can't always just convert to an LLC. So there are issues and that's a tax and accounting issue. You talk to your CPA about that, whether you can actually convert it. So again, I brought up the issue about witnessing. So you can use a spouse to witness. You can use a child 18 or older to witness in your household, or even not in your household. With regard to business planning, good time to take a look at your agreements. Good time to consider agreements if you don't have them. Make sure you're following the rules and regulations of the laws that apply to your company and the type of company. Make sure your intellectual property, trademarks, copyrights are protected, and make sure your valuation formulas in your buy-sell agreements are up to date. I find, and the reason I'm making these comments this morning, are that when you get started in business, you're a startup, it's just you, maybe you do have a partner, but you really don't do a lot of the formalities that you need to because you don't even know if you're going to make it and really get going. And then you get going and you're busy with the business and months and years go by and you never really get back to the actual operational agreements of the business unless you meet me or another attorney or maybe a financial advisor brings up the issue about buy-sell planning and things like that. But very often than not, I get involved with family-owned businesses or larger businesses with multiple partners, and we're doing some estate planning for one of the partners. And when you're a business owner, your estate planning and your business planning very integrated, right? Because there's all kinds of reasons why that's the case. But for example, if you have an S corporation, there are ways if you leave your corporate stock and do certain things where you could break the S election and terminate certain things. So that you generally we put specific language in a will that relates to an S corp if you have it. Um, and with regard to your other things, so if you're doing certain things with your estate plan and who you leave your assets to, including your ownership in the business, that may or may not be going against the other agreements you have in place. By the way, those other agreements will supersede anything you write in your will. So you want to make sure those are coordinated. Very often than not, when I'm getting into situations like that, I find out that things are not like they used to be, or they were never put in place properly, or the real estate is owned by a couple of family members who are no longer in the business anymore, and there's all kinds of complications. So that's why on the estate side I do a lot of work with those family businesses. So all kinds of things to think about. It's a good time while everybody cleans out their attic and cleans out their garage. Also put your personal affairs in order. So again, I'm Mitch Beinhacker, and that is today's legal update, and thanks for listening.